Hi, my name is Jennifer Coleman. I'm a Chief Deputy District Attorney in Clark County, Nevada. I've been prosecuting child abuse and neglect cases here in Clark County for approximately 13 years, with an emphasis on severe child abuse and neglect and child death cases, as well as termination of parental rights. For the past 2 years, I've been focusing on amending processes and procedures here in Clark County to improve timeliness to permanency for children. Today, we're here to discuss reasonable efforts and compelling reasons. Our specific agenda for today is to discuss the PIP findings and requirements, reasonable efforts, and compelling reasons, and specific examples of each. So let's get started. So we have a statewide PIP that has developed various work groups, including the Timeliness to Permanency Work Group. These groups identified solutions and barriers within the TPR process. And the purpose of this training is coming from the PIP to provide training statewide so that our efforts and our processes and procedures across the state are more streamlined. So what are reasonable efforts? Federal law doesn't define reasonable efforts, but it requires an agency to make reasonable efforts. In Nevada, we've codified statutes under 432B 393 that does provide a definition for statutes. And I've made, throughout this presentation, I've made statutory references so that you can use that in your everyday work going forward. I don't plan to read you all of the statutes, so we may scroll through some of those, but they are provided for your reference. So what exactly are reasonable efforts in Nevada? So an agency makes reasonable efforts when they've exercised diligence and care in arranging appropriate, accessible, and available services designed to improve the ability of a family to provide a safe and stable home for each child in the family. As always, the health and safety of the child is a paramount concern. So what are reasonable efforts required? There's 3 situations in which reasonable efforts are required. First is to prevent the removal of the child from the home. Second is to make it possible for a child to return home once removed. And third is to finalize the permanency plan for the child. A couple of key things that I'd like to point out is specifically when we're talking about removing a child from the home, reasonable efforts findings are required to be made under federal law within 60 days of the child being removed from the home. So it's paramount that these findings be made in the first order after a child's been removed. And that can be in one of 2 orders depending on how the child was removed. So the first situation is when a child is removed by way of a warrant order. That warrant order must have the reasonable efforts finding in it because it'll be the first order filed in the case. The other situation is when a child is removed due to exigent circumstances and the child had to be removed to be able to protect their immediate health or welfare. In that situation, the first order entered in the case is the order from the protective custody or preliminary protective hearing, depending on which jurisdiction you're in. And so it would be paramount in those cases that the reasonable efforts finding be put into that order. What happens is if this finding is not in the first order entered into the case, the agency will lose, or the child will lose, 4E eligibility funding reimbursement from the federal government for the life of the case. Once this mistake is made, it cannot be fixed. Reimbursement would be lost for the entire life, and there's no way to remedy it. So it's really important, especially for the judicial officers, to make sure that when they're issuing those orders, that language is in there. To the contrary, when talking about finalizing a permanency plan for a child, Title 4E also requires that the reasonable efforts findings be made every 12 months, at the first 12 months and every 12 months thereafter. Unlike when a child's removed from the home, if that finding is not in your order or in the order, it can be remedied. However, there would be a loss of funding from the time of the last time it was made to the current time. So for example, if you're at the 12-month hearing and that is not put into the 12-month order, but you come back for a hearing in 90 days and it's put in that order, there would have been a loss of funding for 3 months. So what are reasonable efforts to prevent removal? So we'll go through some more specific examples in a moment. However, in-home safety plans is probably one of the key things that we can look at as a focus to prevent removal from the home, as opposed to removing the child from the home and having it as an out-of-home safety plan. Whenever there's consideration being made as to whether there were reasonable efforts to prevent removal, a health and safety of the child should always be the primary consideration or concern that we're looking at. There are also situations where reasonable efforts are satisfied by taking no action to prevent the removal from the home. For example, if a child is in immediate danger, there's a domestic violence incident going on, the child's in the middle of it, there may be no efforts needed to put an in-home plan in place because it may be unsafe to do so at that time. And again, there's the statutory reference for the specific statutory language. So some more additional specific examples to prevent the removal would be present danger assessment, where the agency goes out and makes an assessment of the home to determine, is there immediate danger or is there impending danger? Additionally, the agency could offer in-home or informal services. Many times the agency won't need to remove from the home because we can put a safety plan in place to keep the child in the home, and that may include providing services such as mental health or substance abuse treatment on an in-home basis if a parent is cooperative and willing to engage in those services. And then of course there's the safety plan where perhaps maybe a relative moves into the home to address the times that are identified when the child is in danger. It may be having a friend or a family member come in and check on the family periodically. But these are all different types of things that the agency can do to make reasonable efforts to prevent removal. So let's talk a little bit about reasonable efforts to return a child home. Again, here's the statutory reference. I would urge all the practitioners and judicial officers watching this to read through it specifically, because there's a lot of things that are listed in this statute that are reasonable efforts to return a child home, and there tends to be a focus only on, did we provide the parent with services? Well, there's more to reasonable efforts to returning a child home than just that. So I would urge you to read through all the various different types of things listed in the statute. So what are some examples of reasonable efforts to return a child to the home? What are some specific things the agency can do? Once the child's been removed, even though there might have been an initial assessment for a safety plan, that should be constantly being reassessed throughout the life of the case to determine have things changed, are things different, that we can now put a safety plan in place. Additionally, the agency should be doing the Protective Capacity Family Assessment, commonly referred to as the PCFA. This is the objective tool the agency uses to develop case plan objectives for reunification. Additionally, the agency should be engaging in Protective Capacity Progress Assessments, commonly known as PCPA. This is how the agency assesses progress on case plan objectives. The agency should also be assisting the family in obtaining treatment or therapy for whatever the identified safety threats are for the family or the impending danger threats. Facilitating contact between the child and parent to maintain or create a positive bond is also a reasonable effort to get the child home. Maintaining at least monthly or more frequent contact with the parent. This would include attempts. Just because the worker doesn't reach out and actually talk to the parent, if they're attempting to do it but are unable to reach the parent, that's still considered a reasonable effort. So when are reasonable efforts to return a child home not required? 432B 393 subsection 3 provides a variety of circumstances in which if a court makes certain findings, that the agency can be relieved of their obligation to provide reasonable efforts for reunification. Again, please review through the specifics. Some of the more common ones is if there's been a prior involuntary termination of parental rights. Also, if a child had been removed from the home, returned to the home, and then subsequently removed as a result of additional abuse or neglect, is another common ground in which the agency can seek to be relieved of its obligation for reasonable efforts. This slide is the second part of that statute for your reference. So let's switch our focus to reasonable efforts to finalize a permanency plan. So here's some statutory references for everyone to review. But one of the key considerations is the agency's exercising of diligence and care to achieve the permanency plan, whether it's adoption or other planned permanent living arrangements, or even guardianship. So Nevada law permits but does not require the agency to make efforts towards adoption at the same time it's making efforts towards reunification. This does not require authorization by the court. So what specifically does that mean? So if an agency, let's say the permanency plan is reunification, and the agency has identified that it's appropriate for concurrent plan of adoption, but it hasn't been approved by the court yet. The Nevada law allows the agency to start making efforts towards the agency identified concurrent plan of adoption. So they might start gathering records that are needed for adoption, initiating termination proceedings, recruiting for an adoptive resource, at the same time that it's making reasonable efforts to continue to try to reunify the child with the parents. So the agency can be relieved of making efforts to reunify the family if those efforts are inconsistent with the permanency plan. So again, if there's no concurrent plan and the permanency plan is, say, guardianship, that would relieve the agency of efforts to continue to try to reunify the family. It's only when there's both a concurrent and primary permanency plan where they would have to continue making efforts for reunification at the same time as working on the permanency plan. So what are some specific examples on how to make reasonable efforts to finalize permanency plan? There's kind of a misconception out there that the only reasonable effort that you can make to achieve a permanency plan of, say, adoption or guardianship is to initiate the legal proceedings. But the agency is responsible for much more than just initiating proceedings for guardianship or termination of parental rights. And those are things that courts should be considering in determining whether an agency is making reasonable efforts to finalize a permanency plan or not. So specifically, things the agency can be doing are discussing adoption and alternative permanency goals with caregivers, assisting caregivers with licensing early on in the case. This is especially important if it looks like an appropriate permanency plan would be guardianship with a king gap subsidy, and you'll learn a little bit more about that in a subsequent training. Engaging in mediation, not only the agency, but the caregiver and with the parents to determine an appropriate outcome. Obtaining birth records, completing or updating social summaries, recruiting for a permanent caregiver, and that crosses all three alternative permanency plans as far as finding a permanent caregiver that's willing to have a child, say a child whose plan is OPLA, remain in their home until they're 18 or possibly 21 years old, as well as identifying an adoptive resource or a permanent guardian. Of course, initiating legal proceedings for termination of parental rights or guardianship is also an example of another reasonable effort. And providing youth, for our OPLA children, providing youth with independent living services, job seeking assistance, or assisting the youth in enrolling in school or other types of vocational programs. These are all different things that the agency does to help a child achieve permanency. I wanted to take a moment to talk about active efforts on ICWA cases. Since everybody may not be familiar with ICWA law, it's a federal law called the Indian Child Welfare Act, and it's applicable to Indian children, and it requires states to provide active efforts as opposed to reasonable efforts in child welfare proceedings. However, active efforts differ from reasonable efforts in a couple of different ways. First off, in reasonable efforts, we said that there were 3 times you were required to make reasonable efforts: to prevent the removal, to return the child home, and to finalize the permanency plan. Whereas under ICWA cases, you're only required to provide active efforts to prevent removal and to reunify a child home. So active efforts to achieve a permanency plan are not required under the federal law. The second difference is understanding exactly what's the different level of efforts between active versus efforts. And I've provided an example for you. Reasonable efforts might be only referring a family for services. So let's say we have a drug case, so making a referral to a treatment provider for substance abuse treatment. But in making active efforts, it would be contacting, say, multiple treatment agencies to find the best fitting and culturally appropriate service for the family or for the parent, to help them engage and to help them engage in those services. So rather than just making the referral, you may have to coordinate transportation for the parent to get to the services, or make arrangements for the services to come into their home. Additionally, active efforts would also require following up on the family's impression on how those services are going and whether or not the services are working for them and being successful and helping them. So I hope that kind of helps you understand a little bit better. It's kind of going above and beyond and doing a little bit extra to ensure that the services being provided are really helping the Indian family to be reunified. So before we get into compelling reasons, briefly wanted to discuss proceedings to terminate parental rights. Under the Adoption and Safe Family Acts, which is a federal law, provides various timelines in which termination proceedings must be commenced. In Nevada, we've codified some statutes that I've referenced for you that make those timelines even a little bit more strict. And specifically, we are required, if we have not been able to reunify a child home under Nevada law, we are required to initiate termination proceedings after the child has been out of the home 14 of any 20 consecutive months. And there's a few exceptions to that, and that's provided in 432B553. Specifically, there's exceptions if the child is in the care of a relative, if the plan has required the agency to make reasonable efforts to reunify and has not provided those efforts when required to do so, or 3, compelling reasons that are documented in the case plan for a child. And that's going to be kind of the focus for the rest of our training, is discussing what are compelling reasons and what are not compelling reasons. There's also additionally in Nevada some presumptions related to TPR that need to be considered when determining whether or not a permanency goal should be changed to adoption. And those, again, I've provided for you for your reference in your everyday practice. So what are compelling reasons not to commence termination proceedings? Really, the key thing to remember is compelling reasons is when it's in the best interest of the child to make those findings. Findings should be made on a case-by-case basis based on each child and each family's circumstances. You may have situations where you have siblings that are differently situated within a family, and there may be appropriate to make compelling reasons as to one sibling, but not as to the other sibling. And the final thing is that compelling reasons must be listed in each child's case plan. So let's get to some examples about that. So when are there compelling reasons? So if the agency and the court have determined that a parent has made significant progress and is continuing to make diligent efforts to complete their case plan, and it's in the child's best interest to extend time for reunification, that would be a compelling reason. So for example, let's say we're coming upon the 12-month review hearing and it's time for the court to make that decision on whether or not to change the goal. and the parent, say it was a drug case, the parent is actively engaged in treatment, has not been testing positive for several months, and say the only barrier to reunification is to get safe and stable housing, and there's referrals out, and we're actively working on getting that safe and stable housing. That would be an example of significant progress that a parent has made, where the court might find it appropriate to make compelling reasons based on the parent's progress, and assuming also that that parent is actively and regularly visiting the child, maintaining a bond with the child. That's what would make it in the best interest to extend time for reunification. Another situation might be when a parent is terminally ill and has designated the child's present caretaker as the permanent caretaker. There may be compelling reasons not to adopt termination and adoption as the plan, as opposed to perhaps a long-term guardianship or a permanent guardianship. Another example of compelling reasons is that there's insufficient legal grounds to terminate parental rights as determined by the agency's legal counsel. If the agency has staffed the case with their counsel and determined that, hey, we can't prove parental fault, or we can't prove best interest of child, so we're recommending that we look at an alternative permanency plan. Another situation would be for our older children. Anytime a child is of the age of consent 14, they must consent to a guardianship or adoption. If a child has been counseled on the different permanency plans and talked to their attorney and is unwilling to consent to adoption, this might be a compelling reason as to why it's in the best interest of the child to not make adoption the permanency goal. Some additional examples is when a child has severe emotional or behavioral challenges or serious medical conditions, and reunification remains an appropriate goal. When children are unable to function in a family setting, as documented through professional assessments, this may be a situation where allowing more time for reunification is appropriate. There are some cases where international legal obligations preclude termination of parental rights. Other cases, and our ICWA cases, if the tribe is unsupportive of adoption as a permanency plan and has identified a different plan, it would be appropriate to make compelling reasons findings. If the court determines that the agency has not made reasonable efforts in accordance with 432b(3)93 to provide the family with the services that the agency have deemed necessary for reunification when reasonable efforts were required, it may be also a compelling reason to continue out a permanency plan of reunification. So let's also discuss a couple of inappropriate compelling reasons. So when a parent has just recently started services and asking for more time is not a compelling reason. Remember, we talked about a few minutes ago that if a parent had engaged in substantially in their case plan and had made significant progress and is regularly visiting the child, that it might be appropriate to extend reunification. Well, in that same example, if a parent comes into court and we're at our 12-month hearing and they just started services 2 weeks ago, it's a drug case, they had a recent drug test in the last month. Maybe they're visiting their child regularly, maybe they're not visiting their child regularly, but they're just starting on their case plan and said, look, judge, if you please just give me more time, I can get this done. That's not a compelling reason to continue the permanency plan. It may be appropriate to adopt a concurrent plan, keep reunification as a concurrent plan, but it's not a compelling reason to not start moving forward to starting adoption and termination proceedings. Another inappropriate compelling reason is when a parent has just been incarcerated. And let me rephrase that in that it may not be an appropriate compelling reason when a parent has been incarcerated a good portion of the case. Many times in practice, cases are reviewed and they say, oh, well, the parent's been incarcerated, 9 of the last 12 months, therefore there's compelling reasons. But Nevada law requires more than just saying mere incarceration. In our case law, in Reed JLN, and I've provided the site for your reference, there's a factors test that needs to be applied. We need to look at more than just the mere fact of incarceration. We need to be looking at things of what are they incarcerated for? How long have they been incarcerated? What was the nature of the relationship with the child prior to incarceration? And what have they done to maintain a relationship with the child to the extent possible during their incarceration? So please keep in mind that when looking at compelling reasons, both agencies and the courts need to be looking at the full factors before determining whether or not compelling reasons are appropriate in incarceration cases. Another situation where there may be an inappropriate compelling reason is just when there's an adoptive resource that's not been identified. Just because an adoptive resource has not been identified alone is not an appropriate reason to find compelling reasons to keep the permanency plan reunification. Again, going to Nevada case law, INRI AJG indicates that an agency does not have to prove placement in an adoptive resource or even a search for an adoptive home for the court to make a finding that it's in the best interest of a child for rights to be terminated. So, based on the case law, if you can terminate parental rights without having even searched for an adoptive placement, certainly that can't be used as a compelling reason on its own to find that it's in the best interest of the child to keep reunification as the permanency plan. So I think that factor needs to be looked in conjunction with all of the facts and circumstances of the case, such as the parent's progress and their revisitation and ability to maintain their bond with the child since being placed out of home, are all things that need to be considered in conjunction with whether or not an adoptive resource has been identified or not.